if you'd like to raise a question, raise your hand. We'll do a quick introduction with the panelists, and then we'll dive straight into the hot topics. So my name is Shak Ashraf, Managing Director of Forte Markets and the founder of the Legal Technology and Innovation Institute. I'm pleased to be working with a stellar lineup of experts on the panel, and also Microsoft as a key partner and a sponsor of this initiative. So we aim to run these over the course of 2022, carving them out into more kind of focused roundtables, etc., to look at pain points and to help you learn from your peers and also learn from market experts in terms of what is happening in the compliance and technology space. And as the journey matures around the data protection piece, no doubt we will continue to dive into that and provide support where possible. So definitely prep your questions. I want to come round to you towards the end of the session, but without further ado, let's hand over to Joanne for a quick intro.
Thank you, Shak. So my name is Joanne Fischlin. I head the Government Affairs and Public Policy team together with the legal team for Microsoft based in Dubai. I've been in Microsoft for 5 years. Thank you so much for having me, Shak and Forte Market, and I really look forward to being with you guys today. This is an exciting time to have that conversation.
Excellent. Thanks, Joanne. Dale, over to you.
Good morning, everyone. My name is Dale Waterman. I'm the Managing Director for Breakwater Solutions. I'm based here in Dubai, and I cover some Middle East and North Africa. And Breakwater is involved in all things sort of data risk. So we've got a consulting and a services offering, as well as a product offering around data. Looking forward to the session.
Perfect. Gautam, up to you.
Good morning, everyone. My name is Gautam, part of the Paramount cybersecurity team. I represent Paramount from the Microsoft standpoint. Been selling a little over a decade and a half. Hope to have the best conversation today.
Excellent, thanks. And from the far reaches of Scotland, over to Ramon.
Thank you, Shak. Yeah, thank you for welcoming us to this session. My name is Ramon Bosch. I help Microsoft customers make sense of standards and regulations as it relates to their digital transformation efforts. Right? So I help customers distill the obligations that come from those regulations and turn those into practical technical controls. So thank you for setting up this session, Shak.
Excellent, thank you. No worries, it's a pleasure. So it'll be two parts. We'll start off with a bit of data governance, compliance, the landscape, and then we'll look at the second part, which is technology and tools and how you can leverage existing tools to kind of be better compliant. So we'll start with Joanne then. So Joanne, a bird's eye view really in terms of what's happening in the data and regulatory space in the UAE today. Over to you.
Thank you very much, Shak. Look, as I was saying, this is really a very exciting time to be in legal and compliance in the region. We're seeing new laws pop up in a number of different countries across the region. The UAE has just adopted its, the largest overhaul of its legislative framework in its history. And so what I find is, as an in-house counsel, is that at the same time, this is really, I think, was fundamental for the UAE's growth and bringing them further onto the global stage. But as an in-house counsel, when you get more than 40 laws at the same time, that you have to figure out how to comply to, how they apply to you, how they apply to your business, how they apply to the data flows that your business is involved in. The complexity, of course, of it rises significantly. In terms of the different laws, I think there's, as I said, a number of them. Two, and myself, I'm still going through them and trying to figure out what's what. I think maybe I'll call out two of them, and of course, one is the big topic I think on everybody's mind, which is the data protection law. The other one I would say would probably be Federal Decree number 34, which was just rebranded as the Combating Rumors in Cybercrime Law. This framework is a very interesting framework. It was a very needed update. If you think about, I'll share an anecdote here. Yesterday, I was on a roundtable. We're discussing the metaverse and how do you implement regulations, what laws are going to apply to this, digital environment. And what came out is that part of the conversation was geared towards the fact that the internet, for instance, has been here for more than 3 decades, and we still haven't achieved digital safety on the internet. And so those types of regulations are very needed because today's behaviors and traffic on the internet have created risks that we did not foresee at the time that the previous cybercrime law was in place. So it's very welcomed, I think, because it does tackle today's challenges. And I think one of the biggest challenges that humankind and countries have faced is misinformation, for instance. And so it really tackles this. So for instance, if you publish fake news or if you share fake news on the internet, this has been criminalized. Of course, what I will also say is that there's going to have to be some checks and balances, of course, to make sure that especially the Western world, that of course a big trade partner to the UAE, don't look at this piece of legislation as a tool to limit freedom of speech. And on the personal data protection law, I will say that this is by very far the best piece of legislation in that sector that the region has seen so far. The Saudi have just come up with their own. And what I like about the UAE is that it's very focused at making it easy and kind of business friendly. And when you think that the UAE's economic fabric is small and medium enterprises, I think it's very welcome to see that this piece of legislation will hopefully not bring too much complexity, especially for those companies who are already GDPR compliant and have a framework, data classification and the likes for instance, GDPR or other privacy frameworks. There is, of course, a big lack of clarity. And so I know Dale is going to talk to a little bit more about the law and what it contains. But yeah, I would say my top of mind for the time being is how are we going to figure out exactly what this entails for companies like Microsoft and others in the UAE and beyond.
Okay, perfect. And in terms of any key pieces around cross-border data flows and that, do you want to pick that up later on, or do you want to mention something now?
Yeah, no, so exactly. So that's typically something that they took from. It's largely inspired by GDPR. And so that was one of the core things, be it for companies who have presence in the UAE or elsewhere, or companies who deal cross borders. It's a very welcomed addition to the law that they allow transfers both to what we call in the GDPR terminology adequate jurisdictions, which mean that they have a similar framework, if you want, to that of the UAE, or even those that don't, and then you can kind of put a framework together. At the same time, the way it's drafted is still very open. And so it's hard to say exactly what are the requirements that would have to be in place in those jurisdictions for cross-border data flows to be possible. But at least we're on the path to have clarity on what is it that can and can't cross borders. There are a couple of caveats that I can touch on later, because of course the country also has data residency requirements, and so the law has really tried to tackle those in some sense.
Okay, thanks. I had a bit of a glitch there. Dale, thanks, Joanne. So, Dale, with your experience in this space and obviously the vast knowledge in the region, what are your thoughts? Can we have a kind of a helicopter view of the data protection law, if it's possible, in its current state, where it is in terms of the draft?
Yeah, I mean, I guess that's my chore today. Is that obviously we've had this law land, and we couldn't not talk about it today. It's really obviously super topical this week. But just to be clear, I am going to make it a bit of a speed dating session, one way, and I'm going to try and just give you that high level. You called it a helicopter view. In part because that's kind of where we are right now. We can't actually give too much detail yet, but I think it's useful because people do need to, I'm sure some folks will benefit from this quick introduction, and also I think it provides some great context for the rest of the conversation, which is all around data and compliance. So firstly, it's federal law. It's 45 regarding personal data protection. It was issued in September, the 20th. It was announced publicly to all of us on the 27th of November, so it's kind of hot off the press. The law goes live or is effective as of the 2nd of January, so things are moving pretty darn quickly, although most of us are pleased about that. What's very important is that, and this is quite typical in the GCC region, the law lacks a little bit of meat, so there's a lack of clarity around certain things. People often refer to it as a bit of a living document where you need some iterations. But we're going to be very dependent on the executive regulations. And that will provide us with the detail, and then there'll be some guidelines that will probably follow as well. Have I got an echo there?
Farah, if you can go on mute, please.
And then just to carry on, so the executive regulations will be released 6 months after the issuance date. So that's from September. So we're looking at about the 20th of March or earlier for the executive regulation. So that's a key date for us. And then you'll have 6 months to get compliant thereafter. And there can be a slight extension there. But, bottom line is that things have moved very quickly. I echo Joanne's kind of thoughts. I do think that this is a very positive move. I think the UAE was falling behind the region and globally. And we can have discussions that are philosophical or even ethical. But even from a commercial perspective, I think it's really important that the UAE has kind of started to align more with these global principles. So the law itself, if you're familiar with data protection, is quite GDPR-like or GDPR-inspired. I'm from south of the Mediterranean, so it feels kind of colonial to me when I use terms like GDPR. So I prefer just to talk about global data protection practices, and that's what they've become. And so you'll come across all the terminology you'd expect to see, so sort of fairness, transparency, legal basis, so lawfulness. You've got concepts like purpose limitation, accuracy, security. You'll have a section which covers the obligations that you have as a controller, the obligations that you have as a processor. And these will be things like the sort of technical and organizational measures that you need to implement. You will need to think about whether or not you require a data protection officer, a DPO. So that's around sort of things like high risk processing. And there are also things like DPIAs or data protection impact assessments, which folks will be familiar with. Again, that's predominantly around the use of new technologies like AI. So there's a lot there. For me, the key takeaway here is around this trend, I would call it, of accountability. So previously, data protection regimes were very much about asking for permission to do stuff. And so you had permits and you had licenses. And what's changed is that you now get given a law, you get given your implementing regulations and some guidelines, and you've got to go away and actually create and then implement a system that's compliant with that law. And the big takeaway is it's not just that you're accountable to be compliant, but you're accountable to demonstrate that you're compliant. And that's a key thing, because the burden of proof has moved away from a regulator having to demonstrate that you're not compliant to a situation where they can ask you to demonstrate that you are. And that's where the bar gets raised, because this is where you're now having to collect records of processing activities, and you've got to have sort of operational stuff in place so that you can actually demonstrate your compliance. And that's not only to regulators, that's to your partners, that's to governments, that's to your customers as well. A few notable things, because I've got to be super brief here, but a few notable things. Firstly, consent. It's quite a consent-based system, just generally in the GCC around everything. You had to have consent. We've seen that, throughout all legislation. And again, this starts by saying you may not process personal data unless you have the consent, except when. Now, firstly, it's going to raise the bar on consent because we all get a lot of unsolicited contact. So we know consent hasn't been particularly well enforced, but it will now. And the consent is different because it's going to have to be free, and the terms will be things like, first there'll be purpose limitations, so you can't just get consent for everything. It's revocable, so you've now got a right as a data subject to revoke that consent, which means you've now got to think about how you're going to manage that consent registry and keep it evergreen. And one of the interesting things that is notable in this law is that typically you have about 6 legal bases in the world that are common, but the ones that you would normally use would be consent for the performance of a contract and legitimate interest. And there's been a trend away globally from consent because consent can be withdrawn. You actually want to choose a legal basis that's got longevity, and it's obviously expensive to manage. So people have moved away from consent. In addition, there's also been a movement towards not using consent when employees are involved. And of course, a lot of the data which is personal to organizations is employee data. And the reason for that is because there's an imbalance in power. Is that consent really free? Can you say no as an employee? And people would argue not. And so there's been a move away from consent towards using legitimate interest. But what's notable about this law is there is no legitimate interest as a legal basis, and that can't be by mistake. I don't know why. We're going to have to watch the implementing regulations and see how this plays out. And then very briefly, a few other notable things are: one, government data is excluded from this law, and also data which is gathered by government authorities as personal data and then processed. And that's a biggie, because you'll have folks in Europe squirming a little bit in their seats about this because they've effectively removed sort of that government part from the regulations. And of course, you could argue that from a commercial perspective, you can contract obligations and you can be held accountable to a certain extent, but you can't contract governments. And there are these concerns in the world around surveillance and the use of personal data. And so this will definitely be something that will raise a flag, and we'll have to see how that's addressed in future. I'm sure there'll be something that will address this, but it's certainly not in the law, and it's notable. And then healthcare personal data and also banking and credit personal data are excluded if there's another regulation that manages those. And so we're going to have to look at what those regulations are. We can guess, but it does mean that they sit outside the remit of the law. And the final one, just to mention, is that free zones are excluded. And they talk about free zones being excluded that have legislation. We can insinuate they mean personal data protection regulations, which probably means sort of ADGM and DIFC. But it does mean that they also appear to sit outside of this new federal data protection law. So that's a sort of a brief oversight with a few notable points that I hope are useful to folks.
Okay, no, I appreciate that. And Joanne, anything to add there? So what about the detail around notification of data breaches, stuff like that? Is that there, or are we still waiting for that detail in the implementing regulations? And Joanne, you can take that if you want.
Yeah. So again, I think we're going to expect some level of clarity over notification of data breaches. It's interesting. In some level, it's more flexible than in the EU, for instance, or based on global privacy standards, and on other levels, it's actually more restrictive. And so, it is, for us, it is unclear whether the intent is to limit breaches for material notification breaches. Because of course, and that was a very big topic at the time when GDPR was issued, because if you have to notify every single data breach you have, regardless of how significant it is, not only I think will the office not cope, but for companies, it's pretty much going to be impossible to manage. So let's see where we end up on what might qualify as a breach when we get the implementation regulations. You don't have the 72 hours, so there's no fixed really timeline for you to hand over that data. It's more, you know, as soon as you can, which that definitely gives you a little bit more flexibility, but also uncertainty as to when it is considered that it was timely and when it is considered that it wasn't. I'm sure Dale might have other comments maybe on notification. The other thing I wanted to just follow up with on what Dale said, the other challenge we have is that again, going back to the clarity, government data and government entities are excluded from the scope of the law, yet it is undefined. And so we do not know yet what qualifies, for instance, as a government entity. And that means, is it the likes of ministries or authorities, or does it include state-owned entities, and to what extent? So I think the nuance is very important, because government, of course, is a very large trade partner for a very significant amount of companies in the UAE. And so not knowing which side of the fence those, for instance, state-owned entities will lie is a bit of a challenge until we have clarity on that. Dale talked about healthcare and financial services. We anticipate, for the time being, there's only one piece of legislation in the financial services industry, at least a published one. I'm not talking about central bank potentially narratives that go specifically to banks and not in the public, but what's published. The only data residency we have is across this, and I'm going to call it the e-payment regulation, because it's stored value, whatever the name of this of the store is way too long, but that one has a data residency requirement for transaction data. And so again, going back to clarity, the terminology used in the data protection law and the terminology used in that central bank legislation don't really fit. And so it will be really good to get clarity as to what exactly is the data that we're talking about, because banks churn a huge amount of data, even personal data, that do not fall in the category of credit data as it's written in the personal law, or personal transaction banking data, but could qualify as transaction data. And so it'll be interesting to find out what is exactly going to apply to what type of data. So I just wanted to add to that, and I corroborate what Dale said, which is the fact that government and government data is excluded is potentially going to push this law in the space of being an inadequate jurisdiction. Okay,
and no, thanks for that. The freeze-on point, is it as clear-cut as that? I mean, or is there going to be,
yes,
you know, assessing the landscape in terms of what overlaps versus what doesn't?
So I think it definitely does. It's clear. I mean, ultimately, it opens the route, because you don't want to be talking just about DIFC and ADGM, who are the only free zones who have a privacy law in the UAE. There may be new free zones who have data privacy regimes in the future. So the law allows for that flexibility. I think the challenge will be, for instance, with, I'm going back to banks who are incorporated in the DIFC or ADGM, who have operations on mainland, are regulated both under the DIFC or ADGM regulator and the central bank. And so how are they going to manage personal data? Because on one end, they're going to be subject to data residency, and the other end, they can apply a data regime that is already applying to them. And on top of the mainland restriction, they're going to have the personal data, which this federal law does not match eye to eye with those two legislations that are in ADGM and DIFC. So again, I think the management of how to comply with all of those different moving parts is probably, and I'm looking forward to hear Ramon and Gautam, because I think without technology, it's going to be a little bit of a headache to wrap our heads around it as a start, and also how do you actually comply with all of it.
Okay, perfect. Someone. Okay, so we will come to the tech piece, and I think we'll definitely dive in a bit more into what teams need to do to prepare and what you can do in the interim period of these kind of implementation regulations being published. Before we do that, just taking a step back then, Joanne, and then I'll come to you, Dale. So on the wider kind of maturing landscape of data governance and data regulation, you know, what's coming next? I mean, how difficult a minefield is it to navigate for legal and compliance teams over the next 1, 2, 3 years?
Okay. Yeah, no, very good question. I mean, those 40 new laws are definitely a massive overhaul, but I don't think the road is going to stop there. We're going to see increasing new legislation come up. What's also going to happen is I think the policy landscape is also going to evolve, so I'm probably just going to comment on the cloud part here, because all of those laws, and when you add the cloud, I mean, the cloud helps in one way to manage the compliance, and I think it's a really powerful tool for that. But at the same time, cloud also involves cross-border data flows, cross-border storage, cross-border processing. And so in the space of cloud, if you look at the landscape today, except for Abu Dhabi Digital Authority, who had a somewhat of a cloud-related policy that dates back 2016, which ADA don't even apply themselves, we are going to see cloud-focused type of regulations come up. We are at least aware that the TDRA, so the Telecom, and I think it's the Digital Regulatory Authority, are looking at putting, and they're actually drafting as we're speaking, a cloud computing policy. ADA are revamping theirs. You know, we have in Dubai, we have Dubai Electronic Security Center, who issued information standards back in 2019. And so, again, it's going to be really interesting to see how, if only those three are going to interact, because the chances are that people are going to use one cloud solution. And so how does the country think about streamlining those different policies to make sure that companies who operate across different emirates and at federal level and with federal entities know how to handle a federal entity data in the cloud versus an Abu Dhabi data in the cloud, and versus, so ideally we're going to see some streamlining. Let's see where we land on this. The big one for the future is directly related to what we just discussed on the personal law, data law, sorry, and that's government data law. So the UAE, I think, made a very conscious decision to remove government data out of the personal data protection law. Now is the time where they're starting to put together their government data law. And I think the crux in this one will be whether the UAE apply or don't apply best-in-class data classification practices, so that, first of all, it is clear what can be stored and processed and managed where, and also to make sure that basically companies who deal with government data have clarity on how they can potentially leverage a technology such as the cloud when they manage government data. So that, I would say, is the big one that's coming next in the data space.
Okay, perfect. Dale, anything you want to comment on there, or?
Yeah, like a quick comment just on the government data law. I think what'll be interesting from the privacy perspective is not the government data itself, but the collection of personal data protection by government authorities and how that plays out. Because a key component of kind of privacy legislation is the idea that data subjects have rights and they have remedies. And it'll be interesting to see then how they bake that into a government law if they've sort of parceled off government separately. On the privacy side, just a little bit of advice I would give to folks, because I mean everyone here is regional in the sense that you've got data crossing borders and you've got obviously different offices across the region globally. And the idea really is around harmonization. And I think you were talking about you kind of using a similar concept, Joanne. You were saying streamlining, but harmonization is really the original idea behind GDPR in a way, because you had all these European countries that were doing things slightly differently. And of course, what we're trying to achieve, it's not perfect, and there's obviously some teething problems, is we're trying to achieve harmonization around the world, around data, because that means that as a company, whether you're in Saudi or Bahrain or Qatar or in Singapore and Europe, that hopefully these laws start being harmonized to some extent. And that allows you to build a global program where you're essentially looking at what for now will be your high water mark. You apply that across your company, and then there'll be an element of localization that you might need to bake in, which takes a little bit of work, but it's typically the approach that companies will be taking, because it just, and even Microsoft, for example, the moment they accepted GDPR from a European perspective, they made that level available globally. And there's some benefits to both to Microsoft and obviously to their customers from that. The one other thing I wanted to add as an interest point, I think, is the AI Act that has been discussed in Europe. Don't smile, Joanne. But that was released as a draft in April. But I think why I find the AI Act interesting, because they're basically forming like a risk framework, and they're saying like these are the very risky things in a pyramid, which we are not allowed to do. For example, profile people, and in the sense of sort of the Chinese approach from the government there, to things that are way less risky and have less control. So they've got that sort of risk pyramid where they're thinking about how people are impacted by artificial intelligence. I don't need to say too much more about that. What I think is interesting is that it's likely to start taking on some kind of extraterritorial impact, just like we saw from GDPR. And so basically Europe are going to say, we believe in democracy, we believe in our values. So it's a similar approach to privacy, but this is from an AI perspective, and they're going to impose those on you if you want to play with them from a European perspective. And what might happen is then that law, which is at the moment the first of its kind, could quite naturally spread globally in much the same way as we saw GDPR. And then you have a sort of harmonization of AI acts and how we should be treating personal data and the impact on people around things like profiling. So that's something to watch with interest in the future.
Okay, no, definitely. So you keep preempting part of my next question. So you definitely got a sixth sense or something. So you're making me think of on the fly here. But so let's go back to that. So most in-house teams have a regional mandate, right, in Dubai with the HQ setup, etc. So how does the data protection law impact their priorities? No doubt there's the firefighting, there's day-to-day activity, there's a bunch of regulations, there's the cybersecurity controls, the essential cyber controls in Saudi, the data protection law there. How do they manage this? How do they navigate the priorities? And I'll start with you, and I'll come to Joanne on that, and then we'll go to Ramon and Gautam to warm up on the tech side. Yeah.
Okay. In short, I think it raises the risk. So and even to the comments that Joanne made around sort of breach notification, if you've worked in the industry, and Gautam has from a cyber perspective, you're aware of how many breach incidents are occurring here. Serious breach incidents, but we don't hear about them. And I think we've got to focus on cybersecurity from a business continuity perspective. That's the risk, or perhaps protecting what companies would consider is their confidential data, tender stuff, IP. What I think is going to happen now is, as personal data becomes more valuable and as companies start to collect more of it because they're intentionally reasoning over that data in order to provide better services and products to their customers, the value of personal data has increased, and it should be pulled into that same bucket of sort of important stuff. And once that does, I think that'll change the way that companies start to think about privacy and the importance of privacy, because it goes towards, and I'm going to pull this together by talking about breach. At the moment, if you have a bad day, you call in your experts and you try and remediate as best you can, but you don't have to tell anybody. Now, at the moment, you're going to have to tell your regulator, and until we hear how they clarify sort of the impact or the materiality of that breach, you've got to go tell all your customers. And so, to be slightly cynical, you might not care too much yet about privacy. You, in the sense of you've lost people's email addresses and they're out in the dark web. You might decide that the risk of enforcement is not yet that high, and let's be practical about that. It'll take a while. But what it could really impact is your reputation and your brand and the trust of your customers that you've built up over a very long period of time. And I think that changes the risk lens. And that's going to put some more focus on compliance, not just in documentation, but actually building a program that can actually deliver on your vision, as it were. And that's going to require effort and some budget.
Okay, Joanne, as an in-house lawyer, how are you going to manage the priorities with all this change in the region?
So the increasing complexity is not new. It's been happening for a number of years. It is now at a stage that, even if you're a mammoth like Microsoft that literally has more than 2,000 lawyers, I don't see that without the help of technology, you will be able to track compliance requirements, minimizing the risk of something falling through the net holes. And so I would say that one of the priorities for us, and especially because we know that budget for headcount is never going to increase at the same pace as complexity. And so I would say one of the core priorities would be looking at tech to help you managing this. The other beauty of tech is that when you have as a general counsel or as a head of compliance or as a DPO, when you have those conversations with your exec management, tech also has the ability to show the risk and show where you are non-compliant in a easy to grasp, quick visual way. And that is, I've seen, a very, very powerful tool when you have those conversations about what it is that we need to invest in to make sure we stay ahead of the curve. Being given those tools that can actually empower you to have those business-driven conversations with easy to grasp data by your execs is going to take you a long way.
Perfect. So that's an excellent kind of segue into kind of the tech gurus that we've got online with us. So Ramon, coming to you. So look, let's put on let's look at this with a technology lens. How can we, and with what Joanne's just said, what's the best approach if we just look at data privacy regulations and a technology lens, what's out there? What's your thoughts on how teams can leverage existing and future tools, etc.?
Mm-hmm. Yeah. Before I would even put my technologist hat on, I would rather first put my risk thinking hat on, right? Or my risk advisor practitioner hat on. Because you see, one thing that's evidenced by the back and forth that you just had with Joanne and Dale is that when a new law is enacted that speaks to data and digital, regardless of whether it has already been distilled and instantiated into a regulation with clear obligations to which one can map controls, what naturally happens, and again, that was evidenced in this conversation, is that the focus is immediately put on accountability and liability to an extent, right? So what are the things I must be doing? What are the things I should be able to prove? And what happens, including punitive actions, should I not be able to do those things or prove that I have been doing those things, right? And naturally, that's the first reaction that one has when exposed to a new law, again, regardless of whether there's clarity around regulation already or not. Now, again, if I put my risk hat on, then the first thing I would think is, well, regulation or legislation is really just a second effect or a second order risk, right? It's a compounding risk. It's what can go worse when it's already going bad, right? So I would first call the attention towards what are the things that could go bad in relation to the data that I'm processing, regardless of whether I'm actually a controller or I'm relying on a processor, or regardless of whether I'm in the processor and processing on behalf of a controller. There are things that can go bad when you handle data, right? And that's the first order risk. And the things that one should be doing about the things that could possibly go wrong with data are universal, right? And it's a matter of responsibility, not a matter of accountability or liability, right? And I'm not talking about social responsibility or some sort of a philanthropical act. I'm talking about fiduciary responsibility, right, towards shareholders. What should I be doing to control those first order risks in relation to the data that I process or that I have processed on my behalf, right? So when lawmakers think about cross-border transfers that John alluded to, I would say that really what you're thinking is the first order risk, which is uncontrolled disclosure, right? Transferring data across borders creates that opportunity for uncontrolled disclosure of data. Or when they think about data residency, they're thinking about the same opportunity, right? When data doesn't reside in a certain jurisdiction, it creates opportunities for uncontrolled disclosure. For instance, when faced by law enforcement requests for data outside of a certain jurisdiction. Or, Dale spoke about breach notifications, right? Breach notifications are related to the event itself of uncontrolled disclosure, right? You have a breach, data gets disclosed beyond or without your control, certainly without your consent. So again, what might happen from a regulatory or legal perspective when your data has already been exposed without your control is a compounding risk, is a compounding effect. But what I would say all of us should be concerned with is, well, what do we do about those first order risks, right? And that's universal, and there's certainly technology that helps with that, right? There's things that we can do with technology to prevent data from being disclosed, or things that we can do to minimize the likelihoods that it will be disclosed, right? So again, we can talk more during our conversation about technology itself, right? But first of all, I think it's important to assess what is the real risk, right? And regulation is really a compounding risk, but it's not a first order risk.
Yeah, no, absolutely. And on that, Gautam, let me sort of bring you in then, in terms, and then we talk about some of the tools. We'll circle back. So, what's your thoughts on the ground? Obviously, you've got your cyber background, and you're close to the data protection space, and you're working with clients. What is the acceptance of data protection regulations across, from your experience, and the tools and solutions that go around that?
First of all, Joanne and Dale, thanks so much for all the information. Now that gives me a thought that I should go back and enroll myself into a law school now. So where I come from is a technology background, Shaq. So what I think is technology is like a bridge, and me as a system integrator, I'm a matchmaker between what the law says and what the customer's pain point is. So I have to bridge that gap, and how do I do that? I use a technology which addresses what the law wants everyone to follow, and how that same technology would address what the customer pain point is. Now, here what we have to emphasize is one thing, which is how this specific technology helps implement what the law wants with a successful completion of the project. Okay, that's where we have a win-win. It's not just a win-win, I would say. It's a win-win-win, because the law wins, then the customer wins, and then the partner wins. Everyone's happy end of the day. That's how I would look at it. Now, when it comes to the ground reality, While we all talk about law and regulations, the ground reality is completely different. I would say it is driven by the customer's readiness for a technology or or for a solution. And at the same time, is there an acceptance for that specific technology? Okay, it's not a change or an adoption, but I see it's change in the mindset that we have to bring into the environment today, because that's when we can actually bring a holistic solution which is successful, which adheres to what the law says and addressing the pain points. I'm coming to the same point again and again. Now, generally, where I see or what I look at it is in two different ways. One, it's a consulting approach. Two is a solutioning approach. The most important thing is the consulting approach, because it's not just about a technology which is another check mark in the entire list of things, but it's more to make the end user understand why he needs something like this. Being a cybersecurity specialist, I spend a lot of time talking to customers. I talk to industry specialists like you, where I see, data protection is not just a checkbox. It's not a check in the box. Now here there is a lot of push, either which comes from the decision makers or the regulators on the data protection laws. And at the same time, the customer also himself understands the importance and agrees to implement the data protection solution or the DP solutions. Okay, it's very important on my side to educate the end user as to why he should look at something, and there are a couple of aspects that he should be looking at. Does the customer really know where the data is? Does he know the locations of the data? How can he protect the data? How can he prevent the data from a kind of a leak or a loss? And how can he govern the entire data? So if I bring all of this into the consulting mode, educate the customer, prepare him for the actual journey, which is the solution, I think that's the first step of my journey, or that's first step that we have taken. When it comes to the solution, today the solution is no more a luxury or a good to have kind of a thing. It's more to, it's must to have kind of a scenario, because we've gone past those days. We don't have those luxury anymore. We don't have that luxury of time anymore. Let me give an example here. As an owner of a specific document, or probably I'm working for a company, so I've got access to multiple documents. Now I can decide, before sharing a document, I can decide as to who would I send this document to, what is that the person can do on that particular data, and what kind of access am I giving to this specific person on that specific data? Can he do anything with it, or am I just willing him to, wanting him to read the document, or just use it for that specific engagement? But at the same time, it's also important for us to, it's very important when it comes to a solution like this. It's, the customers should be prepared, and it's, it's of being more proactive than going in the reactive approach, because once you get into the reactive mode, if some disaster happens, then you can't go back and fix it. It's very important for us to be on the proactive mode. Be, just do things on time and with the technology availability, and with law in place, follow the law and bring in the right solution at the right time.
Okay, no, thank you. So look, Ramon, back to you then. So look, give us, off the top of your head, what is out there because look, I've been, around the GDPR implementation for years, and we still have a considerable amount of firms in Europe that are, compliant by the, a bare thread in terms of MVP compliance. It's all tactical. Budgets are always a challenge, as Joanne mentioned, but and time capacity, right? The number of times you look at internal teams, compliance teams, and even tech teams where they don't have the capacity to implement something strategic. And now, almost 4 years after GDPR, I still advise clients on a forbearance approach and how to manage self-identified issues. So what's out there that people can use, that can put them in a good place for DPL compliance?
Yeah. So allow me to go back to my initial thought about, about risk and regulations being this compounding or second order type of effect or risk, right? So the understanding is, of course, that regulation is about accountability, right? And meeting the obligations of a regulation is about accountability, and that the actual concern should always be initially about the responsibility towards preventing bad things from happening with the data that we process, right? But if we focus on that accountability, the problem there is a problem of scale, right? And I think Bill alluded to that when he introduced the notion of harmonization, right? The harmonization that we saw with the GDPR helped solve a problem of scale, right? If you were a company operating in a number of different jurisdictions across the EU, you would have to scale to deal with the problem of the multiple different and distinct regulations in those jurisdictions, right? So harmonization is not really something desirable, but it's unlikely something that we're ever going to accomplish at the global scale. So how do we accomplish harmonization to some extent while not really being able to achieve that from a legal framework perspective? How do we do that then with technology, right? So that's, I would say that's one of the things where those in attendance today could probably focus their attention towards initially, right? It's how do we deal with the complexity that John alluded to? How do they achieve harmonization, which Dale alluded to, through technology, right? And one way to do that through technology is to have technology that can parse through the language of the various regulations out there, and there's a myriad of them or a multitude of them, and it's growing, right? Have technology that parses through the language, that extracts obligations out of those regulations, that then turns those obligations into controls, whether documentational, technical controls, or operational controls, that can then be, especially if they're technical or operational controls, that can then be mapped to technologies, right, that help solve or prevent for those first order risks, right? So again, the regulations concern themselves with things that can go wrong, right? So if we can have technology that distills all the prescriptions or obligations of the regulation into controls that then map into technologies that take care of the actual prevention of the things that could go wrong, then that would help solve that problem of scale, right? That would help organizations, represented in this session here today as attendants, deal with the problem of complexity and achieve some degree of harmonization in the face of, a growing regulatory landscape. And there's a multitude of technology offerings out there, including from Microsoft, that help govern that compliance nightmare, right? That help make sense of that catalog and growing catalog of regulations and turn it into action, right? And I think that's, again, probably one of the first areas that I would advise any of my customers to focus on.
I mean, one of the conversations, I mean, I run the obviously the legal tech program, and one of the scenarios we encountered earlier this year is, the drop jaws when some of the delegates have seen compliance manager and not knowing it existed, and it's possibly there in their enterprise license, and how it's got data regulations mapped out. So is there a very quick snapshot you can, and Dale, I'll come to you then on that, and whether the new data protection law will be available as a template, etc.
Yeah, good point, Shaq. So I'll take a step back. One of, or introduce another thought here, right? One of the challenges that many organizations have as of today, and as they adopt online services and cloud technologies, right, is understand where their responsibility as a controller lays, and where the responsibility of their data processor, be that Microsoft, Amazon, or Google, lays, right? So first and foremost is that understanding of how to engage with the shared responsibility model. So as Microsoft, we've been dealing with that problem of trying to clarify for our customers what we as Microsoft, as the data processor, are responsible for in the face of all these regulations, and what our customers are responsible for. So yes, indeed, a few years ago already, we introduced to our customers an offering, which is Compliance Manager, that does exactly what I described earlier, right? It creates that harmonizing effect through technology, right? It parses all the regulations out there, including new ones being introduced on a regular basis, and turns those into actions, and also the clarity in terms of what the data processor does, in this case Microsoft, and what the customer as the controller still remains responsible for. Right?
Okay, perfect. Dale, got your hand raised?
Yeah, what I wanted to say was we should also remember, especially from the privacy perspective, that like I've heard colleagues in Europe say, man, if we had in 2016 what exists today, it would have changed our lives completely. Like we forget how much has been developed because of something like GDPR. So there's been a whole ecosystem of technology that's developed over the last four or so years. And I think the Middle East should leverage that, because the days of using a spreadsheet and sitting diligently and trying to keep that update, those are long gone, but that's how people started with GDPR. So we should leverage the fact that there's been tremendous development in technology across many, many different platforms and offerings. The other point I wanted to make, I think is quite relevant to the Middle East, and that's around the fact that we tend to look at this from a very legalistic perspective, because we haven't had a privacy law here for 2 decades. We don't have a community of privacy experts, so the default is very strongly towards legal. And so I kind of imagine a boardroom sitting there with a new law that's landed, and I kind of imagine in my mind a GC being pointed at and saying, you're the person you must be the person who's responsible for this. Now, because of that legalistic bias, what tends to happen is that we go off to general counsel and we build a solution that's very lawyerish, which means we go and build a whole lot of policies. And then we wave them at regulators and we say, look, we're ready. What we're lacking is the operational side, because our default as lawyers isn't to go into that world. And that's where I would encourage what will probably be quite a lot of sort of legal and compliance folks on the call to make sure that they sort of open their minds to technology, which isn't our sort of happy space potentially, and to think about some of the solutions that exist there. And one of the people that you can do to help you kind of enter that world is actually your cybersecurity team. Because one of the problems we have in the region, I'm sure Gautam will agree, is we often have very siloed worlds between cybersecurity and privacy, but actually there's a tremendous overlap and convergence between the two. So if you can learn how to bring obviously your legal acumen to help the cyber guys, but they can also bring their operational experience and their technical experience, that's a really quick way to kind of leapfrog and build your program more quickly.
Absolutely. Yeah. Just to add to what you mentioned, sorry, Shaq. I also see these days a lot of discussions that I get into where I see, from the customer side, I do see the legal teams also getting into picture, probably if not into a direct meeting, but they do share their views, because it's not just about technology. It's a good blend that we all have to bring in. So I think it's always important for the legal, the business, and the technology to work together.
The connectivity is key, right? Absolutely. Otherwise, you've got a bunch of policies written by the front line, and the requirements are not translated for the techies to implement, right? And it's always disjointed. Yeah. Joanne, seeing as you're in this space and you leverage tech already, what's from your perspective, anything you want to add to that? What Ramon said in terms of compliance manager, and anything that you've really benefited from?
Yeah, no, so to Gautam's point, of course, about what Ramon mentioned, the collaboration. I mean, usually, IT is not used to talk to legal, except maybe when they renew their licenses for their desktop Windows 11. This is a collaboration that going forward is going to increase and increase, because for instance, when we start thinking about adding a law in Compliance Manager, like we will do for this data protection law, of course, I'm going to sit with our technical compliance team and kind of look at what it is that is going to be top of mind and needs to be tracked, that is actually useful for a legal team like ours. But what Dale said about cybersecurity is also equally important. I mean, now IT teams are not just IT teams. They become system integrators way beyond what they used to be 10 years ago. They become cloud specialists. They become data processing specialists. And so making sure that you have this close connection with whoever is your IT. And in some companies, it's outsourced, but that doesn't mean that you shouldn't have the conversation to have at least an understanding of where those pockets of risks might lie, because your infrastructure might be outdated, you might be considering a move to the cloud, but you're not, as a legal person, involved in that conversation, and yet you would have a big role to play, because a move or not a move to the cloud means potentially better compliance tracking or not. And so really trying to get into that space. I know, again, historically, I'm at Microsoft 10 years ago. You'd have told me go and review one of Microsoft's contracts, I would have shot myself. This was for IT to deal with. That relationship is changing, and compliance officers need to be best mates with their CTO.
Yeah, perfect. Okay, so look, I know people are probably multitasking, having a sandwich and listening to us on the panel. We're eating into your lunch break. So questions, please, audience, just anything you're worried about and about DPL, we'll see where we can help. I mean, I'll carry on the conversation with the panelists, but please just raise your hand if there's anything you want to ask, and I'll come straight to you. So whilst we have people warming up with questions, I mean, I've got a couple more. So, you know, we know that there's this 3-month or 4-month gap between the implementation regulations if they're published on time, right? And then we're hoping that basically they are, you know, the holy grail and give you, you know, the black letter law of exactly what you need to implement in terms of technical standards. But, you know, where do we start in the interim? What, you know, we know that getting ready in 12 months, 18 months is a challenge in itself, right? And that's even if you're starting from the 5s or 6s or in R10. So Dale, I'll come to you then. So what can legal and compliance teams do with their technology teams to get something in place now to make the most of the next quarter, in spite of the implementation regulations not being available?
Look, I think one of the sort of fundamentals is understanding what data you have. And so that talks to data classification. And that's very topical in our region right now. If you've mentioned Saudi a few times, obviously their law launched a month ago, and we're also expecting regulations there in March. And there's a very strong focus in Saudi, and always has been, with the CITC, and now also their data protection law and the NDMO around data governance and classification of data. But from a privacy perspective, to use Ramon's phrase and kind of take a step back, I think one of the key issues is you first need to align with your leadership team around what you're going to do. And that's around what is your ambition level as a company. What buy-in do you need from senior leadership teams? Because as you make decisions around your ambition level, and of course it's going to be a 2, 3, 4-year journey, but that's going to have an impact on you commercially. Because some of these decisions, if you set the bar very hard, have some impact on what some people in your team might be intending to do with personal data in future. So having that conversation is super important, and having it now is exactly the right time. Because when we hit the panic stations of trying to get something in place, you know, there's going to be a focus around just running to your outside counsel and getting something in place. Now's the time to sit down and agree with your leadership team what it's going to take, and really defining, maybe even doing some form of gap analysis broadly, because these are global principles, and then having some kind of roadmap around where you're going to go. Because even though you update all your policies, and even if you go and buy a whole lot of cool technology, if you don't have the support of your leadership teams and you haven't got the buy-in around what it's actually going to take to implement, you're going to fail. So the first step now is to kind of use this time to be a bit planful about what you'd like to achieve. And then I briefly mentioned the data classification, and that's a big play. It's also a technology play, but what you need to understand in having that strategic conversation is what data you have. And you'll be surprised how folks very often won't know, because it's siloed, it's in different parts. And so using data classification, which will be important from a regulatory perspective, but actually understanding where your data is, who has access to it, whether it's crossing borders, how you can tag it, how you can control that data, how you can geolocate that data, something along those lines. And there are many tools that offer that. I mean, Breakwater, we have some of that tooling as well, but there are a few options. And actually taking some time to explore that now is going to put you at a very good footing as you kind of launch your data privacy program. Because that's, I mean, think about it. If someone wants consent removed, how do you do that? Where do you find it? If someone wants a data subject request, where do you go? If there's litigation involved, how do you find that data? If there's constraints around data sovereignty and border crossing, how do you control that? All of that comes down to an ability to manage your data, which is an indexing of your data, and then a classification of your data, and then a monitoring of that data. So that would be some good time spent now too.
Okay, perfect. Ramon, do you want to add to that?
Yeah, I would like to add one thing to that, right? So Dale, and I totally agree with what he said, right? That he said that it's important to first establish the ambition, right? And what you're trying to achieve, right? And articulate that clearly to other stakeholders in the organization. I would take it one step further, right? And it's to say one must articulate first why this is necessary to begin with, right? In the sense that the risks that one takes or is not ready to take has to be commensurate with the opportunity that the organization is pursuing, right? And the reason I mentioned that is because I spent an inordinate amount of my time working with customers to establish what is the right budget to allocate to technologies that help them take risks, right? But if the opportunity is not well understood, how much is the right total cost of risk, right? How much are you going to spend on your risk management programs and on the technologies that support it if you don't put it into the context of the actual opportunity that the organization as a whole is pursuing, that it and for which it makes sense then to take certain risks or not to take them, right? So I think for many on this meeting, understanding that why and then having that inform the budget is probably a starting point, right? Because otherwise the adoption of the technologies that would help scale or would help or harmonize or do all the things that we've discussed here as panelists are not ever going to materialize because there's not going to be enough money allocated towards that.
Okay, no, thanks. Gautam, what's your thoughts on the data classification piece and how tech can help?
So one thing very important, like Dale rightly mentioned, is every organization should be prepared, and they should know where or what are the different pockets where they have their information lying, because we as an organization probably have just started with 10, but the minute I grow to 10,000, I would not really know where my data is, right? That would be probably in all different locations across the planet or within the organizations on a SharePoint or different file repositories or hard drives, email, or it could be on the local machines as well. Yeah, that it becomes very critical for the organization to be prepared to see where my data is. I should properly classify, saying this is important to my company, this is internal, this is external, or and all of it. I should label it correctly, and I should be ready to protect it. And also it helps me in governing my data end of the day. That's how you should build the entire the flow from the time I identify my data to govern the data with all these steps one after the other. And it's very, very important to bring in not just the IT team or the business guys. It's also important for the decision makers and the leadership team right from day one, because it's not just buying something, you should bring that into their mind, from their mind. So it's very important. So that's where I think it's from the leadership team, top to bottom, and then the entire solution right from discovery to the governance. Okay,
perfect. So look, we're almost out of time, so I've got a private message. Look, if you don't want to ask a question out loud, just drop me a private chat, and I'm happy to relay it to the panelists. So on the details, right, the real granular stuff, and I know most of it's probably not available, and I think we've already discussed it in terms of data minimization, how it's not covered. There's nothing much, and then there's the data subject access requests. Is there anything at any level between you and Joanne on those 2 points that you can cover, or is it still finger in the air until March? You're on mute. Yeah.
Yeah, I mean, I do sort of use my joker and say that we're waiting on those, executive regulations. But I mean, we could talk a little bit from the experience of DSARs. So those are data subject access requests. They're painful for companies to go through, because they're often not used in the sense of what you and I might think it should be. Like, I want to find out what data you have of mine, or I want to rectify data, I want to delete it. They're often being used in quite sort of litigious circumstances. So the trend that we saw in sort of DIFC was that they were used by people who were, for example, losing their jobs, which is obviously unfortunate, but then they'd bring a data subject access request as a leverage point. I've seen it with schools here. There was a period, of course, where we haven't had exams. And of course, marks had to be set by teachers as opposed to, the traditional exams of certainly sort of 18 months ago. And you've had people receiving results they weren't happy with, and you've got sort of British curriculum schools here, and you've actually had DSARs, which strictly speaking, you don't need to respond to. But of course, these are private schools. You've got reputations, you've got parents who are upset. And so, whether or not we might see a flood of DSARs happening here onshore, it wouldn't be surprising following the trend. And it is something that people will need to think about, because you're going to have to build a process to help you actually respond to those efficiently, find the data which talks to our classification, supply the data, and obviously just keep the relationships that you have with your customers and your staff.
Yeah, and okay, no, that's a good point. And a recent stat I saw in the UK on DSARs is that the large companies are experiencing almost 500 plus a month, and for some of the larger outfits, it's costing them almost $2 million a year to respond to these. And that's the straightforward ones. And then there's the complicated ones that they need to then go out to outside counsel or external consultants to support. And those are practically almost $40,000 a head in terms of per request. So, and if someone said that 5 years ago, you wouldn't have thought that DSARs were going to be such a pain, right? And people are still dealing with them. So it's definitely something for people to kind of watch out for and start, because the policy or the procedure to respond to one, can be looked at irrespective of the implementation regulations, right? It's not going to be, all right, you may have a mandate of a certain timeline or different levels of classified data, but ultimately the way you're going to do your data discovery and pulling stuff together is something that you can look at in the interim. Because if it's consolidating your data or running a discovery exercise each time a DSAR comes in, putting that tech in place is going to take you longer than 6, 9, 12 months, right? And testing it. And if you miss a data repository and then you've not got everything entirely, how do you kind of cover yourselves for that? So yeah, potentially a big ticket item that people can look at. Joanne, what's your thoughts on the detail around data minimization or the subject's access requests or any other bit of detail that we can probably comment on at this stage?
So on DSRs, I agree with Dale, especially because in this region, on the labour market, unfair dismissal disputes are very commonly used. They can. It's not unforeseen that they move into a defamation case, and so I think it would be good practice if you haven't had a chance to put all of your processes together to make sure you understand your data, where it is, and you can actually formally respond to a DSR request on the long term. In the meantime, I would definitely make sure that you have a conversation with your HR, and that before people are dismissed, you can actually prepare that data in advance so that you don't increase your chances of a poor outcome just because you're not capable of answering such a request, which is usually ancillary. But to Dale's point, often because it's poorly answered, that just puts meat on the bone for the dismissal. So that's probably something that you want to do. In terms of data anonymization, was that what you?
Minimization. So in terms of minimum retention periods and.
I think we're going to have to wait and see. There's not enough clarity, and again, it comes down to how do you classify your data, and once you've been able to classify your data, you will be able to understand what it is that you need to keep, and the same way, what it is that you potentially want to move to the cloud, not move to cloud, depending also on the data residency requirements that you might be subject to.
I do think, if I can add, it talks a little to the technology play, because look, we all want to minimize data because it's not just a data protection principle. In other words, only keep what you need and only gather what you need. But it's also there's cost implications for this, you know. So in the past, of course, we have a culture here of hoarding data. It obviously stems from the days when it was paper and you've got, you know, massive warehouses that are filled with documents. It's now gone digital, but we all appreciate that we're gathering way more data than we ever have. So I think the principle of minimization is something you can start to think about now, because it's just good business practice.
Yeah,
it's thinking about how you can start gathering data in a way that, you know, a lot of business guys will take whatever they can. A lot of the dev teams will take whatever they can. And it's being a little bit thoughtful around what data do we need? What data, how long should we keep it? So to retention periods, how do we go about finding that data and deleting it? And so there's a little bit of work that can be done. And all of that stuff is facilitated, obviously, through some policies and process, but very much through technology.
And will it be, look, and with these, you know, the free zone, the onshore, offshore kind of scenario, in Europe, when we implemented GDPR, the challenge we had is gold plating, whereas different jurisdictions had different requirements on minimum retention periods, irrespective of, you know, what GDPR dictated in terms of its technical standards. So will there be that concept across the DIFC, ADPM regulations, et cetera, and the DPL, or is that something as a TBC?
This is tricky because there's so many different laws, different industries, and it's not all just about data protection here. And so retention periods is really an area where I'd suggest people get some independent legal advice. So use your outside counsel. I'm sure they're going to be getting the questions, so they should have some ready-made answers, but it's not always clear, and there's sometimes some risk decisions that need to be taken around how long you should retain. But that's definitely one for the lawyers.
Yeah. Joanne?
Yeah.
On any gold plating piece, do you think that's fine? Okay, look, so we're almost running out of time. What I want to do is it's a huge topic, right? And I think we're definitely going to get together again after the new year to kind of talk to our audience and ensure we can help them on their journey, and hopefully take some questions directly or offline. There is, and before I ask you all to wrap up with kind of your key kind of takeaways or a couple of points on what people could be doing now, have they mentioned CCTV at all? Because I know when GDPR came out, CCTV was a big topic in terms of, is it included, is it not? Does it identify an individual, etc., or is it a TBC again? Joanne? Yeah.
So no, it's not in the legislation, and I do not anticipate it to be part of future implementation regulations. It's just, I don't think it's in the line of how the country wants to take this forward. I am anticipating, you know, Dale was talking about the AI Act, the European AI Act earlier on. At some point, we are going to see somewhat of a framework maybe pop up in terms of cognitive services, facial recognition, and the likes. But I mean, let us be very clear that CCTV is a tool that the government will and will continue to use on the long term. And this specific piece of legislation has a caveat for public safety interest, whatever you want to call it. CCTV is clearly something that will fall in the security angle, and as a result will be excluded from the protections that this law provides. National, obviously, security is called out specifically in terms of beyond the judiciary. So this does not apply not only to the judiciary authorities, but it also doesn't apply to security companies. And so CCTV being government owned 100% in this country, this falls in this caveat.
Okay. So even as a private enterprise, in terms of what you've got on your premises, we don't know yet, or it won't be covered, but we can come to that, no doubt, in 2022. Tons to talk about.
So you, in your private premises, you're going to have to deal with the data that you collect in your CCTV the same way you deal with any personal data, because the data you collect is personally identifiable information, right? It's an image of you, it's a video of you, and so that privately collected information falls into the personal data bucket, and as a result you'd have to comply with this law. Of course,
that was the focus, really, and I think it's because there was a lot of debate originally. I think you've got lessons learned from GDPR now in terms of what people are doing with their own premises data, and then there was a bit of noise about residential cameras and what they do, etc., etc. So it's Pandora's box to an extent. Dale, June. So look, we're about to wrap up. Let me go do a roundtable. I'll start with Ramon. What would you summarize in terms of, just from a tech perspective, what people should be doing or could be doing over the next 3 to 6 months to get themselves in a position to be for readiness for a massive 2022 for this regulation and no doubt others? Yeah.
So my wrap-up thought would be, none of the problems that we've tabled here for discussion is singularly hard to solve for. It's just that there's so much of it and all the time, right? So it's really a problem of scale. And that's where technology comes in, right? And if we talk about solving for scale through technology, cloud becomes almost an inevitability, right? So what I would suggest is that those that haven't started to apply cloud computing towards solving problems in general or problems of compliance, they start to look into that and consider to apply cloud technologies towards actually preventing bad things from happening to data, or from just governing compliance, right? No matter what the problem might be, when you apply technology and technology that scales, things become easier.
Okay, excellent. Gautam, what's your thoughts?
I mean, after all I heard and after all I see every day, I think it's very simple. You should protect the data which is at rest, data which is in motion, and data which is in use.
Perfect. Okay, Dale, over to you.
I don't know if I can be as short and sweet. One of my tips would be is we're going to have a lot of folks building a lot of paper governance now. They're going to be updating policies, employment contracts, DPAs, possibly privacy notices internally and externally. One of the key takeaways is, as you do that, make sure that you designate roles and responsibilities, because what typically happens is, if it can be very template based because we're cost sensitive, and you end up with a very generic template which feels like a great policy, but you haven't actually agreed who is going to be responsible from a role and responsibility perspective. So make sure as you go through that you designate that, because you can have the best intentions of the world, but if you haven't designated that responsibility to folks, it's not going to get done, and you're going to get some frustration in future.
Perfect. Joanne, final words?
Yeah, I was going to say it's hard considering everybody took my ideas. I would say know where your problem could come from, and again, if you're already aligned with some other privacy frameworks, it might be easier than if you start from scratch. But if you start from scratch, start now, because those timelines for implementation are very, very, very short. GDPR had an 18-month implementation timeline, and it was still considered to be way, way too short. So here we're looking at maximum basically a year, subject to them being on time with the implementation regulations. So know where your data is, classify your data. That means work with your IT team to have an understanding of what policies need to be put in place, both as what we consider our policies in legal, but also how your IT needs to implement data-driven and data-focused policies. And so that would probably be the first thing that I would do.
Thank you very much. And final words from me. So I think that I've seen numerous implementations over the years where they're fixing problems now because it was done by the business or it was done by IT only, so the connectivity wasn't there. And I'm still talking to clients where they're talking about database encryption or auto data deletion requests and stuff like that. So the first thing to do tomorrow is to build your working group around who's your technology accountable person, who's going to be from the business, compliance, senior stakeholders, and start talking about a delivery plan, because you can't wait until March, and a year's not enough to get ready for data regulation. So, and start experimenting, talking to techies, see what you've got in house, see what you've got within your existing technology stack, look at your enterprise license, etc., etc. And we will obviously touch base again come February with you guys to see what's happening in the market, to talk to our panel and to keep you abreast of developments. And also we'll aim to have them as slightly smaller groups, so people are a lot more comfortable in talking about pain points and challenges. But aside from that, I think everyone have a really good Christmas and a break and a fantastic New Year. And welcome to the Monday to Friday working week, which means when I'm not in Dubai, I can get to enjoy my Sunday and the kids won't be going mad. But it was an absolute pleasure. And look, we kept attention of everyone for a whole 90 minutes, which is great. And there's lots more to come. So stay safe and thank you very much. And thanking the panelists especially.
Thank you, Shaq. Thank you very much.
Thank you very much, Shaq, and everybody.
Thanks,
Bye.
Bye.
Bye-bye.
Thank you so much. Bye-bye.
Bye.